Sure.
Welcome to Partnerships for Profit, the podcast where we bring you inside the world of joint ventures, strategic partnerships, and powerful collaborations. Whether you're looking to expand your network, find new referral partners, or scale your business, you're in the right place. Let's get started.
Welcome to Partnerships for Profit. Today we are joined by Donald McGarrah, who is a nationally recognized trial lawyer and a partner and senior trial lawyer at McCready, Garcia & Leet. Donald, welcome to the show.
Thank you. Good morning to you.
And good morning to you as well. I hope I got all that information correct. We just realized right before the show we had to kind of switch it up. I hope I got all those names properly.
You did. It's fine. No worries.
Great. Well, Donald, can you start off by telling us a little bit about yourself and a little bit about your role at McCready, Garcia & Leet?
Yeah, I've been, I'm not going to admit how many years I've been doing this, but I've been in the trial business for a number of years. I'm located in Chicago. The firm that I'm with, McCready, a lot of people just refer to it as McCready Law. We've got offices in Chicago, Minneapolis, St. Louis, and Indianapolis, and we've got a couple of offices here in Chicago. I have had the pleasure and the blessing and the privilege of working with some very, very fine trial lawyers during my career. I came up here to work with a gentleman who's no longer alive, but he was considered the dean of the plaintiff's personal injury bar in the United States at the time, Phil Corboy. And then I was with another great firm here in town called the Wildman Herald Allen and Dixon firm. And so I had a number of great mentors, and I've had the opportunity to handle catastrophic cases for both plaintiffs and defendants. I've handled cases as lead trial counsel in state and federal court in 38 different states. And that's cases involving catastrophic personal injury cases. A lot of them have been cases involving, very sad cases involving neurologically damaged infants. I've handled a ton of product liability litigation. I've handled a lot of property subrogation litigation for both plaintiffs and defense. I've advised mid-market manufacturers who've got sales in the $50 to $75 million a year range in terms of risk issues. A lot of those types of companies, if they have a legal officer, the person will be wearing 10 or 12 hats. And so had the opportunity with some of my former partners of coming in and helping deal with very significant risk issues, help them place coverage, help them deal with potential punitive damage issues. Most of the work I'm doing right now is on the plaintiff side, but as I've indicated to you, I've had the opportunity and opportunity is the way to say it, to have some great mentors on both sides of the street. And I can tell you without equivocation that helps assess these cases in a realistic fashion, because the world that I'm in is a world which revolves around risk. You're talking about risk prevention, risk mitigation, risk management. And when you go to look at one of these cases, you need to understand and evaluate the evidence, what will be admissible at the time of trial. And quite frankly, I prefer on cases to be going up against lawyers who are very good and know what they're doing, because we typically evaluate cases the same way. And that's a way to get the cases resolved in a more cost-effective fashion. And, there's times where good lawyers respectfully disagree with each other in terms of the value of a case or whether or not there's liability. In the civil world, you have to prove as a plaintiff liability, and you have to prove that there was a breach of a applicable duty. That breach was what we call a proximate cause of the damages to your client. And then you have to show the nature and extent of the damages. So I've been on both sides of that equation. And sometimes, the lawyers respectfully disagree with each other in terms of either the liability scenario, causation, or the nature and extent of the damages. So I don't know if that answers your question, but that's kind of where I'm coming from. And I have handle cases in venues that are as large as New York City, Chicago, LA, and as small as Accomack, Virginia, which is on the Eastern Shore, or Eagle Pass, Texas, which is down on the border between Texas and Mexico.
Well, it sounds like you sort of, handle a kind of a wide variety of cases and a wide variety of matters in your role. Is there any, does that, I guess what I'm asking is, does that present a particular challenge, sort of being that varied in the variety of cases you handle?
Well, most of the cases I've handled have been in the product liability arena, or in commercial litigation, or very complex medical litigation. And I've done it for a long time. Now, some of the other things in terms of the work that we did at the Wildman firm with respect to advising these mid-market companies, other issues as they arise. Most of these companies had either an in-house legal counsel, they didn't have a legal department, or they had an outside lawyer who was working as their in-house counsel. So we would kind of work together as a team and figure it out. And the Wildman firm was a full-service firm, so we had people who could, and many times, have the answer. I'm not going to, dig into something that I don't know, but what I'll do is go out through the resources and the network and the connections that I and my partners have. We'll get the answer. We'll get the right answer, so that, the advice that we're communicating to the client is correct advice. And then the client can make an informed decision and a reasoned and responsible decision based upon, the actual assessment of any potential risk.
And you mentioned 38 states you've tried cases in. Does sort of operating in that large of an area and across state lines present any, unique challenges?
Well, I look at it as an opportunity. There is a challenge in the sense that you need to understand your venue. Trying a case in Cook County and Chicago is, quite frankly, a lot different than trying a case in the western suburbs of Chicago. DuPage County is one of the most conservative counties in the United States, and Cook County is considered just the opposite. Now, having said that, if I'll go back to this little town, Accomack, Virginia, which is out on the Eastern Shore. That's a relatively conservative area. I hired in that particular case, researched and hired a local counsel who had been there for many, many years and had an exemplary reputation. So we worked as a team down in Eagle Pass, Texas, and Brownsville, Texas. You have to be very, and this is not unique to Texas or Virginia, but in any area, you need to be aware of the cultural norms, and you need to try to understand that. And so what we would do is hire local counsel, someone who knew the area, and we would do that as a team. And in a lot of those cases, whether they were the neurologically damaged infant cases or the product liability cases, our team from our firm would take the lead on the key issues, simply because and when I say we, I'm not talking about me, I'm talking about the team that I work with. We would have the extensive experience with respect to, for the manufacturing arena. I had already met with everyone on the board. I had talked to their senior design engineers. I talked to the specialists in manufacturing. I wasn't any smarter than anyone else, but I had the knowledge based on the deep dig that we did in terms of understanding every single significant aspect of the design, manufacture, performance of the products that were at issue in the litigation. And so we would then our team would then work as a team with our local counsel, who would know the local venue. They would take the lead in selecting the jury, and we would then divide responsibilities in the case. All of the technical issues would be handled. I would typically handle all of those simply because I knew our experts, I knew the opposing experts, and I knew the issues. But we would do that as a team. So I looked at it as an opportunity. It was fun understanding different areas that were both considered, quote, conservative or not conservative. But, I found for the most part, that when you have people who serve on a jury, most of the jurors that you find, regardless of where you are, try to do the right thing, which is something that I think is gratifying. Occasionally, you have circumstances that are atypical, where you'll have someone who will try to come in and control the jury, kind of be a bully, so to speak. And in many cases, and I would hope in most cases, the jurors, under those circumstances, other jurors would not be intimidated, and people would do what they're supposed to do, is to evaluate the evidence, apply the law to the evidence, and make a fair, reasonable, and responsible decision based on all that information.
So, and I'm curious. You mentioned this earlier, this idea of this term, and now, mind you, I'm going to pull back the cover for you. A lot of times when I don't understand something, I say, "Oh, could you define for our listeners?" What that means is, could you define it for me?
Sure.
But this notion of subrogation, can you define that a little bit and discuss that notion?
Sure. Subrogation is if you own and operate an automobile, and let's say you're in an automobile accident, and there is another party who is at fault. Your insurance company has the right of subrogation, meaning that they can pursue whatever they've paid to you. You report that to your insurance company, assuming that you do that in a timely fashion, you comply with the terms and conditions of your policy. Your insurance company should take care of your property damage. But then they have the right, which is the right of subrogation, in terms of going against the insurer for the other driver to recover the money that they've paid to fix your car. So that is a very simple example of subrogation. In terms of property subrogation, there's a case that I handled, the resolution of which is confidential, but it was in one of the smaller towns outside of Chicago, involving a very, very sophisticated piece of equipment that brand new went for between $2 and $3 million. There was a fire, it caused extensive damage. And so there were, I think, 5 different law firms involved with 5 different sets of experts and people. That was a property subrogation matter where different insurers who had paid out significant money to repair this machine that had been burned were looking to be compensated by other insurers if, in fact, they can establish that there's fault on the part of someone else. That happens a lot in fire cases. You can have a fire and let's say you have a multi-million-dollar loss, and then you bring in what are called cause and origin experts. You look at the physical evidence. These people have an extraordinary level of expertise, the true experts. They look at the physical evidence. They can generally tell where the fire started, how it spread, whether or not accelerants were used, the cause of the fire, and things like that. And so if you, let's just say, and I'm not trying to minimize the one case I was talking to you about. I'm not going to talk about the precise value, but let's say you've got a $20 million loss, and you've got a debate among 4 or 5 different parties as to what caused that loss. That's when you run into a number of very, very good trial lawyers who go out and hire the best experts. And those are fascinating debates. You learn a lot about design, manufacture, engineering, failure analysis, and other associated issues. But the idea behind subrogation is just finding a party who is at fault for a particular loss and making a recovery. The insurance industry does that all the time, as they should, and that's written into your in most policies.
Now, you also advise companies on risk mitigation. Is that correct?
I have. I don't do as much of that right now, but I certainly have. With respect to risk, if you can, the algorithm is risk prevention. So if you can prevent risk, you want to do that. Risk mitigation, if you have risk associated with products and services, you want to, and something happens, you want to try to figure out what happened and why, so you can mitigate the risk. There's risk management. And when you're talking about, someone in the manufacturing arena, the standard in the United States is putting out products that are reasonably safe in design and manufacture and function, as opposed to absolutely safe. You can make an absolutely safe car, but it would be extraordinarily expensive, be like driving around in a tank. And so that's not, you don't have a market for that. You may have a market for that in certain areas of the military, but certainly not with you and me in our day-to-day vehicles. So you've got a manufacturer is going to put out products that are reasonably safe in design. The firms that I've been with in the past, there were several circumstances. I can't get into some of the details because of the fact that it's confidential, but where you have a situation where, a risk situation occurs, you have to then go in and figure out the who, what, when, where, and why. Was this something that was anticipated during the design of the product? If so, how was that managed in the design fashion? If so, was that managed in a reasonable and responsible fashion? Nowadays, most manufacturers have if they have the right people in place, they go through that algorithm. There's people who are specialists in that arena. And so that fortunately for all of us, the vast majority of products are reasonably safe in design. And when you have litigation over those issues, and these are elements that you need to assess whether or not you're representing an injured individual or a manufacturing individual, is what happened and why.
Right.
And you need to really understand the evidence. There's a very famous line from a film that a lot of people are familiar with Tom Cruise and Jack Nicholson. And now the name of it is escaping me. It's the military case that he tried. It'll come to me before the end of the broadcast.
Yeah.
But he plays a lawyer. And
did you order the Code Red?
Right.
Yeah,
Absolutely.
that movie.
Code Red, yes.
You need me on the wall.
Demi Moore was in that film, and Jack Nicholson and Kevin Bacon was his opponent. But one of his statements, though, he says in the movie is very, very true. It doesn't matter what I believe. It only matters what I can prove. Well, in my experience, it does matter what you believe, but you also, as a trial lawyer, have to be very mindful of the fact that there are rules of evidence. And there's a lot of times where I'm sure you've experienced this when you've interviewed people that you think are very credible, and some others who may not be very credible. It's a visceral response. You have a visceral reaction, and I'm not suggesting that you should ignore that, and I don't ignore that in the practice of law and in risk assessment. But if it turns into a dispute, a multi-million-dollar dispute, and I've got I'm representing one of the parties, then I have to focus on the evidence. And part of my job not only is to focus on the available evidence, but to figure out what evidence I need to go out and get. So, if you put together, we had teams, and our firm has the resources here. I use investigators from time to time that range from people who have gotten training and become a private eye, so to speak, a private investigator. But a lot of these people are retired law enforcement. And so some of the cases that we handled on a national basis, we used retired FBI agents. Their training was extraordinary, and their ability to get the evidence, because anytime you had a loss, the same algorithm applied. You want to find out what happened and why. And these companies, the companies that I represented, were, quite frankly, very responsible in terms of dealing with losses, because if they discovered, for instance, that some of the parts in one of their products had failed due to some sort of defect in the actual metallurgy of the product or something like that, they were very aggressive and assertive and appropriate in trying to get those cases resolved and accepting responsibility for that. At the same time, if they found out that there was the basis for the case was lacking or didn't exist, they were willing to go try those cases. So, but that's part of your job. And that's part of your job on both sides. And that applies, certainly all of my work has been in the civil arena, but you still assess risk in the criminal arena as well.
Right. Well, and I'm curious, and I mean, you sort of answered this question, but, I'd love to go deeper down the rabbit hole of it.
Mhm.
When you're working with clients at McCready, Garcia, and Leet, is it sort of when your approach, is it sort of a one-size-fits-all strategy, or is everything you're doing highly custom tailored to the individual client and the needs of their case?
Well, I mean, the answer would be yes to both of those. Number one, if you're handling a civil case, and here we represent the plaintiffs, you have what's called the burden of proof. And so if you have a product liability case, we have the burden of demonstrating that the product at issue is defective in design or manufacture, and that can be either a design defect, a manufacturing defect, a defect in warnings. We have the burden of proving that. And there's very specific instructions. They're called in Illinois. There's a manual called the IPI, the Illinois Pattern Jury Instructions, and it has elements in there. And so we have to be able to prove those elements. You have to show that the manufacturer had a duty to design and manufacture products that are reasonably safe in design and manufacture and function, and that there's been a breach of the duty. And what that means is the manufacturer did not do their job. In other words, let's say in the example I gave you a few minutes ago, for whatever reason, some of the materials are defective. Well, the manufacturer is still responsible for that. And then getting back to your point about subrogation, if that manufacturer went out to the XYZ company to get those materials, and that's where the problem arose. In other words, the manufacturer used the standard process to manufacture their product and it failed because of bad materials. The manufacturer then has a cause of action against the materials manufacturer and provider. But as a plaintiff, we have to show that there is a defect in the product, that defect was a proximate cause. In other words, it was a cause or contributing cause of the incident. And we have to show that it caused the claimed damages. And if you're talking about a personal injury action, that's also done through expert testimony, and not always through expert testimony, but many times through expert testimony. You use that with your physician. So if you've got someone who's been injured by a product and then they were taken to an emergency room, they were admitted to the hospital, they were seen by a neurosurgeon, they had to undergo very complex neurosurgery. At some point, you'll take the deposition of the neurosurgeon, you'll ask the question, Doctor, do you have an opinion based upon a reasonable degree of medical certainty as to whether or not the incident which occurred on such and such a date was a cause or contributing cause of this neurologic condition? Yes, I do. What's your opinion? It was. And what's the basis of the opinion? Well, it's based on my examination of the patient, the history, blah, 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 whatever evidence is out there. And so to make a long-winded answer longer, every one of these cases has those elements.
Right.
Now, you also, though, need to understand the strengths and weaknesses of your case, and that includes the strengths and weaknesses of your client, whether or not they're going to make a good witness or a bad witness, whether or not they understand the process. Same thing for your opponents, same thing for your experts and your opponents' experts. I tried a case many, many years ago here in Chicago, a medical malpractice case, and I was representing one of the defendants. It went for 8 weeks. One of the and it was a plaintiff's verdict, and it should have been a plaintiff's verdict. There was liability among some of the defendants, but one of the individuals who was sued, a physician, I would refer to him as a classic Marcus Welby. I'm showing my age here, but a classic Marcus Welby type personality, is someone who was he would be like your favorite uncle or your grandparent. In other words, a very kind man, very articulate, very warm. The jury loved this gentleman. Now, he was one of the people that dropped the ball, but they didn't find against him. Now, that's a very, very extreme example of the jury's love for this gentleman, perhaps allowing them to ignore some of the evidence or not consider that.
Right.
That's a very extreme example, but look, that's part of the process. And I've had one of the manufacturers that I represented, one of our experts, I wish I could have called him in every one of my cases all over the United States, regardless of the kind of case, because the jurors loved him. This was a man who was honest. He was respected. He had an extraordinary resume. He had an extraordinary affect. He was kind, and he was just, so that makes a difference. So it makes this long-winded answer longer. You have a process which is uniform, but you need to tailor that to every particular circumstance.
Right. Now, this might be a big loaded question, so get ready for it.
All right.
But, I mean, you've had this, nationally recognized trial lawyer. You've had this, I mean, really great career. I mean, working in, 38 states. I mean, I'm curious, when you think back, whether it be with McCready Garcia and Leet, or, any prior firms that you've worked with, when you think back on your career as a whole and all of the people, all of the, business owners that you helped, is there an individual or a business that you helped that that really stands out, that you saw a positive outcome or transformation in as a result of your help and guidance? And could you share that with us, if so?
Well, I mean, from a defense perspective, again, I'm not going to disclose the names of the company, but there were a couple of companies that our firm handled litigation for on a national basis. And in both circumstances, we put together teams. The first company, we had 7 or 8 lawyers working on the litigation. The second one, I think we had 4 or 5. Over a period of 2 to 5 years, that litigation went away. And that was a combination of managing current claims, modifying the design of the product, offering, looking at the circumstances. And these companies were extraordinarily responsible, putting out additional information. So I thought under the circumstances that it was you're working with people who are responsible, who have integrity, who want to do the right thing. And there was a problem, potential problem with some of these circumstances, and I can't get into the specifics of that, but these people responded to that and put a plan into place. So, I mean, I personally and our team was very proud of that because it was a win-win situation. And so from a defense standpoint, that's something that I'm very appreciative of and very blessed to have been part of that experience and feel very, very good about that. And as a plaintiff, I'm not going to get into a lot of the circumstances. This is confidential, but there was one of these cases that I handled for some parents whose little girl was unnecessarily injured significantly, permanently for the rest of her life. But the parents were just great people. And the dad called me about a month after we settled, and sadly had been diagnosed with skin cancer, and he was gone 11 months later. But he was very, very appreciative that we were able to secure I'm talking about our firm. I was certainly lead counsel, but we were able to secure a very significant settlement to provide it for this little girl's special needs for the rest of her life. So those 2 experiences would be the remarkable experiences that I've had.
And everything that you have done throughout your career, I mean, kind of the, overall theme that we've been discussing is everything throughout your career that you have done has been about helping families, helping individuals, just helping people. Where do you think that drive to help others comes from? Do you think that that's something that's just innate to your character, or do you think that that's something you've cultivated along the way?
Well, I mean, I was very, very fortunate to grow up in a family that my father excuse me, and he's been gone sadly way too long, and we lost my mom about a year ago. But my dad was in the Navy for 38 and a half years, a very, very honest, hardworking, responsible, and accountable individual who was very humble as well. He was one of the very, very few people who enlisted in the Navy as a seaman third class. And when he retired, he was a 2-star admiral. And he was on, I'm sorry, I'm going to get a little, he meant a lot to me. He retired on the, one of the admirals on Seaclant, which is the staff of the Atlantic Fleet. And so my older brother was an admiral as well. But these people, my mom and dad, were very, very humble. They were not politically driven. They were just simply good people. So that's the ethic from which I came. And so my parents said, you conduct yourself with integrity and you treat others with dignity and respect, and things will be just fine. And you know what? They're right.
Absolutely. I love that. And I think that that's a great message to end on. Donald, this has been an absolutely amazing conversation. If anybody out there could use the help of McCready Garcia and Lee, could use your help, where can people find you?
Well, I mean, we've got a website here, and if they just Google McCready Law, McCready, McCready Law, it'll pop up. And my contact information is there. If someone wants, my email is donald@mccreadylaw.com. That's pretty simple. And I'll give you my other contact information. If anyone ever wants to go through you, I'll be glad to work with them. And as I've indicated, it's interesting. Most of the people I represent now are plaintiffs, but I still work with people formally and informally, in the risk space on the defense side, simply because of the network that, I've developed over the years.
Well, Donald, thank you so much. This was an absolutely fantastic conversation. Thank you so much for joining us on the show today. This has been great.
Thank you. I appreciate the opportunity.
And thank you, everyone, for listening. This has been Partnerships for Profit, presented by LeDuc Entertainment. Donald, thank you so much again.
Thank you, sir. Take care.
Thanks for joining us on this episode of Partnerships for Profit. We hope you've gained valuable insights on how to form profitable partnerships and take your business to the next level. Be sure to subscribe and leave us a review wherever you listen to podcasts so you never miss an episode. Got a partnership story to share or someone you'd like to see featured on the show? Reach out to us. Until next time, keep building those partnerships for profit.